Now, let's say you own in a city that doesn't have its own local moratorium, and you have a tenant. We're here now in the month of November. So you have a tenant who did not pay their rent on November 1st. They're not claiming COVID. So you give them this new 15-day notice, for the late rent. If they don't pay, they don't claim COVID, what can you expect to be the next step?
Well, if they don't pay and they're not claiming COVID and you serve them the 15-day notice, and they do not file one of two things is going to happen. They're either going to file the declaration or they're not. If they do not file the declaration, you have the right to bring an action for unlawful detainer or an eviction.
And when can you expect to go to court?
You're touching on the question of how backlogged are we in court. It's really interesting. It depends on the county and the court. So there are some courtrooms in LA County right now that are moving relatively quick. There are other courtrooms that are just slow as molasses in the winter. LA is probably the most backlogged of them all. I have a couple cases downtown that we filed in December of 2019. And because for various reasons they filed motions and they delayed it and then COVID hit, those cases still don't have a trial date. They've been continued and continued. We've had the trial date continued 6 or 7 times now. But I'll say this. I just had a case that I filed a month ago in Pasadena. And we've already had a COVID-related hearing and we won the hearing. In other words, the court denied her COVID protection, which allows me to set a trial now. So it depends on the county, how backlogged the county is. It depends on the specific court and courtroom. It depends on the judge, how tenant-friendly or landlord-friendly they are. But in the end, even on that case where we won the motion, they're going to set a trial date. The question will be, will that trial date get kicked down the road? So it's hard to answer your question in black and white terms, other than to say, I think in general, we are going to look at anywhere between a 3-month and 6-month backlog, depending on the court or the courthouse rather, for getting cases through.
I can just see landlords watching this video, thinking to themselves, they don't know if they felt worse before watching our video or worse now, knowing the reality of the state of where things are. But I think landlords need to know we can't have our head in the clouds and we need to prepare for a worst case scenario. Now, let's say a landlord owns a building where they pay the utilities on behalf of the tenants.
Yes.
Most landlords pay water because it's rare to find a multifamily building where water is separately metered. So we'll put water aside, but let's say you're paying electricity or gas and the tenants are not paying rent. Well, can you cut the utilities because there's no income?
Absolutely not. In California, there's a specific code that prohibits landlords from either turning off utilities or allowing the utilities to be turned off, especially when they're in their name. And here's the bigger problem. If you're a landlord and you either stop paying utilities, which results in them getting turned off, or you intentionally have them turned off, you are engaging in what would be called constructive eviction. And that gives the tenant, it's an unlawful eviction. You force the tenant to move without actually filing an eviction, and you could face significant civil penalties for that. So I hate to say it. Look, like you said, I don't want to be Johnny Raincloud to all your clients and members, but they need to know the truth, because I do have clients that have done that and have found themselves in a lawsuit where I had to tell them, look, this is not a lawsuit you're going to win. You violated the law, which is specifically designed to protect the tenants. Landlords are in a bind. There's no question about it. I don't know how some of them are going to survive. I have people calling me every day saying, look, I'm 3 or 4 months behind in my mortgage. That deferral is going to run out. I'm going to lose this building. And I don't really have clear answers for them right now. It's unfortunate. But to answer your question, no, you can't. You basically can't do anything that would force that tenant to vacate, because you're opening yourself up to a lawsuit for unlawful constructive eviction. But on the utilities, there is a specific code that specifically prohibits that type of behavior.
Yeah, I think bottom line is, the good days are gone. I've had clients tell me that, they've been landlords for, 30, 40 years, and that they would walk in courts like in Long Beach And literally it'd be them and the tenant in front of the judge. And the judge would simply ask, did you pay your rent? No, I didn't. Get out. You know, it was that clear cut. Landlords, of course, see the law still that way. Yeah, it seems to make sense to us. But of course, tenant advocacy groups care to differ. So here's this question. We have a landlord who filed an unlawful detainer in March of 2020. The tenant didn't respond. However, I was not able to file the default and judgment because the court was closed. What do they do with this case now?
Officially, the courts are now allowed to enter defaults and default judgments as of October 5th. That came right out in, I think, AB 3088. Yes, definitely 3088. But we are running into a situation where it depends on the court again, and especially in Los Angeles. We're running into a situation where we've had default judgments that have been filed now for, over a month, going on 6 weeks. And the courts are not entering those defaults or the default judgments. And we've been in touch with the supervisors of those departments. And the supervisors are telling us, I don't know if this is true or not, I tend to believe it is, but the supervisors are telling us that the internal policy now is that the judges themselves have to sign off on all of these defaults and default judgments, which is causing a delay because the judges have a lot of other things to do as well. So basically, in what used to be an ministerial task, a clerk used to just, as long as the document was filled out correctly, they rubber stamp it and it goes through. Now the judges actually have to sign off on these defaults. So again, I'm going to give the clerks or the supervisors that are telling us that the benefit of the doubt, assume it's true, and state that is not in every court. Some courts, they're entering them right away. Other courts are significantly delayed. There's a couple cautions I would give your members. In the unfortunate event your members are trying to do this on their own right now, and they're the ones calling the court, don't upset the clerks. Be nice, be polite, be professional, because if you, pardon my French, but if you piss off the clerks, your documents have a way of getting lost, or they end up in the circular filing bin, if everybody knows what that means, the trash can.
Right.
Clerks can extract revenge on people. So be polite, be courteous, don't blame them, don't get heated and angry at them. They're just doing their jobs, and they're doing their jobs the way the internal policies are being handed down to them. I hate to say this, but landlords, if they face that situation, I would call every couple days and be patient. I certainly would not call every day. I would get to know the clerk I'm talking to. I'd ask their name, be very friendly to them, ask them how they're doing, how's their family doing in this. Get to be friendly with the clerks, but there's not a lot that landlords can do about this default judgment issue right now. The law provided, as of October 5th, the law provided the courts with a mechanism to enter them and the right to enter them, but the internal policies are preventing that from happening. And candidly, Kris, the laws on this stuff are so convoluted that, and really, I'm an attorney who does this every single day for a living, and I love what I do. And I've probably read AB 3088 now 25 times, just every day going through it with different fact scenarios. And I still every day find a scenario where I'm like, hey, I think I have to look that up and try to figure out how that will work in this situation. So if a guy who does this every day for a living has to keep going back and trying to figure it out, can you imagine what the courts are going through and the court clerks are going through, and everybody's still trying to figure all this stuff out?
It sounds like our eviction process is just as good as the electoral process in Pennsylvania.
Yes. Yeah, that's a great perspective.
All right, here's the next question from one of our viewers. Tenants says they do not need to pay the 25% of rent. So they're talking about the 25% provision in AB 3088 by January 31st of 2021, because City of LA law supersedes state law. And the City of LA says rent is deferred 12 months after the end of the emergency period. Is that true that the City of LA law supersedes the state law?
No. The short answer is no. So there's a lot of confusion about this, like other aspects. But AB 3088 does not supersede every moratorium in every aspect. And even myself, initially, I thought it did. But after you read it and read it and read it, you realize it only supersedes local moratoriums in a couple areas. But this is one of them. You just stated accurately what LA's moratorium says. It says it's deferred for 12 months after the end of the state of emergency. But we talked about this in a prior question. AB 3088 specifically preempted that and said, no, rent is due no later, the payback period is due no later than March 1st of 2021 and cannot go any longer than March 31st of 2022. Now, as for that 25%, I think the tenants would be making a serious mistake if they relied on somebody's interpretation that they don't have to pay that because it's deferred. I would tell any of your clients who have a tenant that say, I'm not going to pay you the 25%, for right now, remain calm. And on February 1st, file your eviction. I would find it very hard to believe that any judge, after reading AB 3088, would allow a local moratorium with a payment period that's got that kind of moving target, especially as far as when it's deferred through, to allow that to supersede AB 3088. I just don't think it's going to happen. The tenants are required to pay it by January 31st. AB 3088 is clear about that. And it's, like I said, that section is specific, has language that specifically preempts moratoriums.